I'm joined now by All Rise News' Adam Klasfeld. Adam, everybody saw yesterday's big ruling from the Ninth Circuit Court of Appeals allowing Donald Trump to continue to deploy these troops into Portland. But there is something that everybody seemed to have missed, and that is one of the messages that was sent by the sole judge who dissented in this opinion. Granted, it was a three-judge panel, two Trump judges, one Clinton-appointed judge. Can you explain what this Clinton-appointed judge did here?
This Clinton-appointed judge, Judge Susan Graber, is widely known as a moderate. She's been on the bench, as you noted, Brian, since Clinton. And she ended this ruling in a very fiery way where she called for the en banc panel of the entire court, the entire bench of the Ninth Circuit, to immediately block this ruling, finding that the legitimacy of the judiciary itself is at stake. I want to read the final two lines because it's as powerful language that you do not see in judicial rulings. She writes, "I urge my colleagues on this court to act swiftly to vacate the majority's order before the illegal deployment of troops under false pretenses can occur. Above all," she adds, "I ask those who are watching this case unfold to retain faith in our judicial system for just a little longer." Just a little longer. She knows that patience is running out.
Yeah.
Time is running out for people who see what is happening, who are seeing judges bend over backwards to accommodate a radical interpretation. One of the judges on this panel, by the way, is the first judge in any of these courts that we have seen so far to have taken the position that seems to agree with the Trump administration's position that the president's determinations on where he gets to send a federalized National Guard are unreviewable, are not subject to judicial review. We'll see how the Supreme Court looks at that one. That is an argument before the Supreme Court right now.
Now, you had mentioned here that she was appealing to her colleagues. What you mean here is that she's appealing to her colleagues on the full bench of the Ninth Circuit Court of Appeals. So she basically recognizes that she's in the minority in what she's claiming is an erroneous decision here put forward by the three-judge panel. Those other two judges are Trump appointees, and is immediately calling for the full bench of judges, the 29 judges who sit on the Ninth Circuit, to review this thing to make sure that the decision handed down by her panel doesn't stand.
Absolutely. You have that exactly right, Brian, she's calling them to rule so swiftly that the illegal deployment of the troops, as she puts it, is blocked. Now, right now, the Trump administration has the green light. They can send in the troops to Portland per this Ninth Circuit order. She wants her colleagues, the entire bench of the Ninth Circuit, to move that quickly so that doesn't happen.
Now, how unorthodox is it for a judge sitting on any circuit court to basically say that their panel handed down a decision that was so misguided, so baseless, that they're calling for the full bench to come and take up this issue so that the panel's decision can be vacated?
Calling for en banc review itself isn't unusual. What's unusual is the emergency language and tenor of this opinion from a judge who's known as a moderate. She sees the urgency here. She has, in a very excoriating opinion, her colleagues, the two Trump appointees on the panel, found that Trump couldn't effectively enforce the laws of the United States using the regular forces. She mocks that decision. Here's what she says. I like to highlight the ruling whenever possible because sometimes the language just cuts to the core. She says,
Right.
"Given Portland protesters' well-known penchant for wearing chicken suits, inflatable frogs, or nothing at all when expressing their disagreement with the methods employed by ICE, observers may be tempted to view the majority's ruling, which accepts the government's characterization of Portland as a war zone, as merely absurd. But today's decision is not merely absurd. It erodes core constitutional principles, including sovereign states' control over their states' militias and the people's First Amendment rights to assemble and to object to the government's policies and actions. I strenuously dissent." Now, a couple of things about that passage. The two other judges were apparently so cut by those remarks that they had to add in a footnote of their ruling that, of course, we do not agree that Portland is a war zone. They went out of the way to say that they disagree with Donald Trump, that Portland is a war zone. They just want to grant him the kind of deference that would allow him to send in the warriors, but also to kind of lay out the facts of what preceded Trump federalizing the National Guard. She highlighted the police reports in Portland in the 5 days leading to the deployment. And each of those 5 days, the police were reporting nothing much is going on. There are about a dozen protesters in front of the building. They actually, the day before Trump authorized federalizing the National Guard, wrote that energy was low energy, and there were no disturbances. Forget about one that couldn't be contained with the regular forces. So what's unusual here is a judge saying that her colleagues have gone so far astray that there is a crisis of confidence in the judiciary itself. And of course, her colleagues' ruling falls right when this matter in the deployment of the National Guards is in front of the Supreme Court.
Now, we've spoken about the fact that there needs to be one of three conditions met to be able to deploy the troops. There has to be a foreign invasion, there has to be a rebellion, or a failure of the local government to be able to effectuate its laws. If these two Trump-appointed judges on the Ninth Circuit panel agreed with the scathing dissent that there was no war zone in Portland, but that Trump just has carte blanche anyway to be able to deploy the troops, why even have a test where conditions have to be met? If they're saying that Trump could just wake up one day when, it's 70 degrees and not a single person on the street and not a single arrest, not a single murder happening in the last 6 months and just deploy the troops, why even have that test if they're just claiming here that Trump has carte blanche, unrestrained power to do whatever he wants, to be able to deploy anybody he wants at any time for no reason whatsoever?
What they're claiming is that in June and July, there were some violent incidents. They had to go back to the summer to find these conditions and said that the judge below shouldn't have geographically limited it. And they set out and try to imagine what this particular standard, if it adopted more broadly, what city doesn't have violent incidents, including incidents involving protesters.
At some point, at some untold point in the past. So you can point to violence in the 80s and say, well, there was violence then. The Rodney King riots were pretty violent. So Trump, of course, needs to have unrestrained power to be able to deploy the military whenever he wants.
I think he captured the absurdity of it perfectly, Brian, because as I read this ruling, I don't see what time limitations are imposing on this, what kind of standard there is here. And that's why you have Judge Graber in the dissent saying repeatedly, we're supposed to be about facts, not about political motives and obfuscation and the fabrication of evidence. That's one of the words that she uses. So she's pointing to the kind of emergency nature of the perception of this. I'll point out here's one of the paragraphs from a concurring opinion from one of the two judges who found that, yes, that Trump has the power to send the troops into Portland. He's the one who, this is Judge Nelson here, believes that the decision should not be reviewed by the courts. He says, reasonable minds will disagree about the propriety of the president's National Guard deployment in Portland, but federal courts are not the panacea to cure that disagreement. The political process is, at least under his view of current Supreme Court precedent. So one of the things that he does not address in the concurrence, at least I don't believe, is the use of the military being used to intimidate, chill the political process. That's one of the concerns being mentioned in the dissent here by Judge Graber.
Well, of course, at the end of the day, Trump is going to get what he wants here, pending, of course, the ruling from the en banc, the full breadth of the Ninth Circuit, and, of course, the decision from the full breadth of the Ninth Circuit. But if this stands, then Trump gets what he wants because there was a ruling that defied the Trump administration in the Seventh Circuit Court of Appeals. Now we've got, at least for the moment, a ruling that agrees with Trump in the Ninth Circuit Court of Appeals. And so we've got this circuit split. And when you have a circuit split, that's one of the conditions that would allow the Supreme Court to take up this issue. And so how are you thinking about this as it relates to any impending Supreme Court ruling as far as Trump's troop deployments are concerned?
Well, the case is already in front of the Supreme Court because of the appeal
Seventh
over,
Circuit.
yeah, because of the
Yeah.
Seventh Circuit decision. Exactly. So what this will do, it will put another opinion, and so instead of opinions in front of the Supreme Court for their consideration. I think it's absolutely time for folks to start imagining what happens if the Trump administration's view here, if Donald Trump's view here wins and carries the day, and he has this wildly expansive ability to send in the troops wherever he wants. Interestingly enough, Brian, in the Supreme Court, the very day that this Ninth Circuit ruling came down, there were a group of National Guard veterans and Marine veterans arguing against this expansive power because, in their view, this is going to erode the military. Let's take a bird's eye view here. The kind of abuses we're seeing around the country have been the pepper spraying of protesters, clergy, and the tear gassing, even of local police in their communities. That's been happening by ICE. Where the National Guard has been sent, they've been sent to guard ICE officials in front of buildings. We haven't seen that from them. What concerns these former veterans who are now appealing, who are going to the Supreme Court, submitting what's known as an amicus brief, known as a friend of the court brief, to have the Supreme Court consider their point of view. They're worried about what this means for the military. They say that it's going to degrade the military because the military will be perceived, the National Guard will be perceived as an instrument of Trump to send to blue states to police protesters and compromise their goal. I want to read a little bit from their brief because I think this is the big picture issue we need to look at in the future if the Supreme Court upholds this wildly expansive view of Trump's ability to send in the troops. He said they write that an unnecessary military deployment to support the president's law enforcement priorities creates an impression that the military serves him and not the country, violating the military's bedrock commitment to nonpartisanship. A departure from that commitment could result in a shift of the composition of the military toward those who support the president's political agenda, driving out those who do not share that agenda or do not believe the military should be used to advance it. It goes on in that regard, but saying that this risks creating the impression of a military and the National Guard, much like Trump's ICE, that it's to use his priorities and his agenda, and that's why these veterans are fighting that right now in front of the Supreme Court, urging them not to let Trump take that step.
And finally, how long do you think it'll be until the full Ninth Circuit bench decides whether or not to hear this case?
It could happen very quickly. Judge Graber said urge them to act before a deployment. I wouldn't be surprised if we hear something in very short order.
Of course, it's ultimately not Judge Graber's decision. It's up to
Right.
it's up to the party in the case to be able to appeal for en banc review. Correct?
Absolutely. And I think, but sometimes it happens sua sponte. We saw that with the other, meaning sua sponte, a judge takes the action without the party asking for it. That's what happened in the Newsom case originally, when Governor Gavin Newsom had sued to block the deployment in Los Angeles and lost in the Ninth Circuit in the initial round. A judge from the Ninth Circuit advanced the en banc review on the judge's own. So we could see that happening here. We could see it moving quickly because, as I said when this began, Brian, this is an unusually strong siren call from the dissenting judge. Act quickly. Confidence in our judiciary is on the line. That's what Susan Graber is saying.
Yeah, and look, she's absolutely spot on. We will continue to cover this. For those who are watching right now, if you'd like to support Adam's work, and this is fearless, independent journalism, he's not part of some major media conglomerate. All Rise News is his outlet, and oftentimes when he's traveling across the country, he's shouldering the cost of that travel just unto himself. So if you're looking to support good, independent journalism, I'm going to put the link to All Rise News right here on the screen and also in the post description of this video. Adam, as always, thank you so much for the time.
Thank you, Brian. Always a pleasure.